We'll
Okay.
go ahead and do the presentation. Good evening, everybody. I'd like to introduce Leonard Levy. Lynn, I've known for many years. I've done many mediations with him over the years. He's a fabulous mediator. I don't think I ever not settled a case.
Mhm.
Uh, so that says something about his prowess as a mediator. He's agreed to do tonight's presentation. I believe he did plaintiff work and defense work in his former life before he was a mediator. I'll let him introduce himself, give us a brief introduction, and then go ahead and do the presentation. And Lynn, I want to personally thank you for doing this again. We appreciate it. The Bar Association appreciates it. It's going to be recorded and available for members in the future if they miss tonight's presentation. So with that, Lynn, go ahead.
Well, thank you. Thank you, Lori. It's always a pleasure. It's always a pleasure to see you. It's always a pleasure to see the group. It's best if everyone turned on their cameras. That would be great because it's a lot more fun, at least for me. I am a full-time mediator and arbitrator with ADR Services, and Lori's correct. I did do plaintiff's work and defense work for many years. I tried cases for about 30 years and have been actually mediating since 1998. There was a kind of a transition period, as is common with mediators. And I mediate in a variety of areas: personal injury, mass tort, employment, business, insurance, construction, real estate, and commercial law primarily. I handle primarily complex litigation matters. I've had trials that have lasted as long as 6 months. Well, to be fair, 4 months, hung jury, come back Monday, try it again for another 2 months. That was a fun 6 months in San Diego. But I'm also an adjunct professor of law at Loyola Law School. I teach negotiations, and my course is my course is Introduction to Negotiations. I also currently host a podcast which is called Masters of Dispute Resolution, and this presentation tonight is kind of, in a way, like my podcast, in a sense that what I try to do is I try to design, and I try to design this talk to benefit both mediators and attorneys who are participating in mediation of complex multi-party mediations, recognizing that really fundamentally mediation is a collaborative process. I appreciate Lori's kudos about never having failed to settle a case with me, but that takes more than me. It takes people like Lori who understand the difference between mediation advocacy and trial advocacy, people who understand what it is like to engage in a collaborative process where all the participants bring tools which have been acquired through education and training, as well as experience in mediation. I mean, Lori, I don't know how many mediations you participated in, but I will bet there are hundreds, at least hundreds, maybe more than hundreds. Okay. So the approach of many attorneys is to think that the mediator should have all of the answers and as to how a mediation is to be conducted. And certainly experienced mediators will be able to approach any particular conflict with a wide variety of tools. But let's not overlook the fact that attorneys have also acquired many tools useful in achieving resolution and that more effectively advance the client's interest. And that really is what we're trying to do in mediation. Everybody is trying to do that, advance their client's interest, and mediators try to reconcile those interests. Now, approaching a mediation, attorneys know or should know the facts and party dynamics and history of the conflict and the client's interests, while a mediator has to rely on and be educated on such things. But the attorney should look at the concept of educating the mediator as more than talking about the client's position or interests. Suggestions to a mediator as to how the process might be approached, given the dynamics that you as attorneys have, can make a difference, a big difference, as to whether resolution is or is not reached. And in multi-party mediations, this is especially important. So I want to tonight provide you with some additional tools with which to approach your role in mediation, whether you're an attorney or a mediator, or an attorney who wants to become a mediator, or an attorney in the process of transitioning into mediation. All right, let me share my screen here and pull up the, there we go. Let me, pardon me, I want to maximize that. Okay, hang on. There we go. Okay. So let's see here. There we go. All right. So everybody can see the PowerPoint, I take it. Okay. So yes. Most commercial mediation involves multiple parties. Construction cases involve multiple parties. Mass tort cases involve multiple parties, as do environmental, business litigation with multiple business partners, shareholder disputes, etc., and bankruptcy proceedings. Bankruptcy proceedings have multiple creditors. So although multi-party mediations are in many respects no different than two-party mediations, they have unique characteristics which require awareness of those characteristics, as well as planning and execution to avoid pitfalls that might otherwise derail a mediation. A general example of how the mediation process becomes more complex is that it might be more difficult to reach the zone of possible agreement. The acronym is ZOPA, Z-O-P-A, by comparing the parties' alternatives, or BATNAs, if all of the parties need to agree and one party has an alternative that's better than the other parties. So that's just one example as to how it can make things more complex to have multiple parties. Now, many of the examples that I'm going to use will come from two areas I think provide the best illustrations of the problems and solutions. I'm going to give a number of examples in mass torts and in construction defect litigation. However, these illustrations have equal applicability to mediations in other substantive areas. Now, in terms of my background with respect to mass tort cases, I was first introduced to those many years ago. It started out as a U.S. District Court case, and the first case I got had 68 plaintiffs. And I had never done a mass tort case, and this one involved, it was a products liability case involving women's hair product. And I've also done child molestation cases, which involve multiple parties. And I've also done construction and construction defect cases. I represented sureties for about 30 years, and as well as contractors and owners. And virtually every construction case is going to involve multiple parties, except, maybe if you have one homeowner who's filing a claim on a contractor's license bond, you may have it one-on-one. But even then, you're going to possibly bring in the surety and the contractor. So you've got almost an automatic multi-party case. Okay, so now approaches to multi-party mediation. It's basically, mediation is basically a facilitated negotiation. I mean, that's really what it is. There's a text that I use for my course by Gifford and Reed called Legal Negotiation that identifies two basic non-exclusive approaches to multi-party negotiation. One is coalition bargaining, and coalition bargaining, as I have up on the screen, and you're going to be provided with a copy of this PowerPoint. You have basically, it's common in construction mediation, and for example, you'll have groups of subcontractors who, with competing interests, such as collecting contract balances from a contractor. But what they can do is they can get together and essentially pool their strengths against the contractor, and that is an example. Coalition bargaining. You enter into a coalition with other similarly situated parties, and the parties' tactics in coalition bargaining can be competitive, they can be cooperative, they can be problem solving, but they're more often than not, it's going to be a combination of those tactics, those types of tactics. Now, in holistic bargaining, a second way of approaching multi-party mediation, everyone negotiates together to identify a proposal or a package of proposals that satisfies the parties' interests. And generally, a cooperative or problem-solving approach works best. And I make a reference here to a concept called log rolling. Let me just lay that out for those of you who may not know what that is. It's basically trading concessions on different issues on which the parties place different priorities, so that both parties are more satisfied than if they reached an agreement through trading significant concessions on the same issues, basically. Okay, so regardless of the approach that you're going to take, the main areas of consideration are going to be your planning and structure for a multi-party negotiation, a multi-party mediation, what mediation tools are available, and anticipating the need for creativity when normal tools don't work. And I'm going to go into all of that. All right. So first of all, let's talk a little bit about planning. Those of you who have mediated with me in the past know that I like to have a conversation prior to the actual mediation session. This is even more important in multi-party negotiations and multi-party mediations. But what's also important is, if you are going to have a mediation that involves people from out of state, for example, in the multi-party case, the mass tort case the first one that I did, there were carriers from back east. There were attorneys from Chicago. There were attorneys from New York. And attorneys from California. And so you're going to be dealing with a lot of people who are outside of the state, and trying to explain at the time of mediation starts as to what the rules of confidentiality and are going to apply to that mediation, it becomes a little burdensome at that time. And you should have that clear in the very beginning. What rules of confidentiality are going to apply? Are they going to be the rules of California? Or are they going to be the rules of some other state? States such as Maryland have rules, for example, that mediators have to be cannot be at all evaluative. When I say evaluative, give the parties, this is what I think about the case. All right, because then that becomes a settlement conference, and then that different rules apply. So you really do need to be clear as to what the rules are that you're going to be following. It also makes it clear as to who's going to be paying the fees. And that's something that, of course, every mediator likes, but it's also something that every party should know. Okay, who's picking up the tab for this, or what's my share? Okay, this is especially true if you have multiple parties. All right. So what a mediator is going to do is to review the materials that are submitted. And one of the things that you can do as attorneys is provide the mediator with a clue, as to more than a clue if possible, as to whether there are claims by parties that can be negotiated at the same time. And again, I'll give you an example from that first mass tort case that I had. There were 68 plaintiffs. Okay, so wait a minute. What are we going to do with 68 plaintiffs? Are 68 plaintiffs going to show up? Are they not going to show up? And how are you going to approach that? Okay, who's going to show up? One of the clues that you can give is pre-mediation demands. Very important to do pre-mediation demands in that kind of setting, because in that particular case, for example, we had let's say we had 5 demands of 5 different plaintiffs of 150,000. We had another 5 of 125,000, another 5 of 100,000, and then they go from there. Well, the defense responses to, let's say, 5 of the highest demands may differ. They may offer, for in response to a $150,000 demand, to 3 of the plaintiffs, they may say, okay, our offer is going to be $50,000. But to the other 2, no, we think the offers to them are going to be $35,000. Okay, so now we have a plaintiff's attorney who thinks these 5 people have a $150,000 case, or at least an initial demand, and we have the defense agreeing that at least 3 of these people are similarly situated to each other. 2 of them are not. 2 of them are maybe situated to the other two, but not to all 5. And so what you can do is you can say, okay, look, let's negotiate for the ones with the highest demands and the highest offers first. And then what we can do is we can use that as a basis for going after or attacking the other claims. Okay, so that's just something that's gleaned from initial demands. But there's much, much more that you need to do in planning planning those types of multi-party cases. The nature of the dispute, including the core issues in contention really should be identified from each person's point of view, from each party's point of view. In one of the cases that I did later on, one of the core issues in contention was that the defense, and this is reflected to a degree in the demands. Initial demands, let's say, are 6 figures. When you have offers being 2 figures and 3 figures, you go, whoa, wait a minute. What's there? There is a disconnect here. What is the core issue in contention? In that case, it was the defense was not given sufficient evidence of causation between the product and the injury. That became the core issue in contention. One of the other things that you need to do is you need to identify the parties, the number of parties, and you should also have a conversation with the mediator about how extensive a brief is going to be useful for that mediator. And have a discussion about what the facts are, what the issues are, etc. And how extensive does the mediator need to be educated? There are some personal injury cases that I've mediated. One with at least one person I know in this room, who where the plaintiff's attorney, came in with briefs that were came in with a brief at 10 o'clock the night before, 9 o'clock mediation the following day, and the brief was most of the brief was what a slip and fall was. Now, by the time I've mediated for over 20 years, I think I know what a slip and fall is. So I don't have to be educated on that. That putting that stuff in there, it just doesn't help. Think about what's going to help the mediator, help you, right? Let the mediator know what information has been exchanged and what is needed. This is especially true from the defense side. If you're not giving the defense side a sufficient amount of information where they can actually go back to their folks and say, we need to roundtable this and talk about where we're going with this. If they don't have that information and you show up at a multi-party mediation, it's like it's an absolute waste of everyone's time. Absolute waste. You have to get out of your mind the idea of we need to play this close to the vest. I often will tell people in mediation that unless you have what I refer to as a trial gotcha, you've got a great impeachment of a particular witness, the key witness on the other side, you need to share information because that information is going to be useful in both sides reaching an agreement. All right. Now, one of the things that you need to be able to do as well is you need to identify let's see here, the logistical problems that need to be addressed. The client has to be notified of the extent and discuss this with the mediator. How extensive do we need the client to be involved in a mass tort case, for example? In a construction case, you may need the client to be involved extensively. A project manager may need to be involved, may need to attend every session of that mediation. All right. What you're also going to need to do, and again, I go back to this, when you have 68 plaintiffs, what kind of consents are going to be needed for the plaintiff? How are you going to get the plaintiff to understand what's going on? Is especially if the plaintiff is not going to be attending, and in those types of situations, plaintiffs very often are not attending. Who is going to be attending? Who has the authority to authorize settlement? And is there a need? And this is a key point, number 5 here. Is there a need for settlement of individual claims, or can there be a lump sum settlement? That is something we're going to cover a little bit later, but that is something that is really important to know up front. Because if you can't negotiate a lump sum settlement, what you're going to need to do is far different in terms of the dynamics in the mediation than if you could negotiate a lump sum settlement. Also, is there a parallel action? In a mass tort case, there may be a class action. And is opting out going to be something that is going to need to be addressed? Right? Okay. One of the most important things, really, to understand in planning and structure is in very many mass tort cases and in construction cases. And this also happens when you have construction defect cases. Very often you'll have a sale of the property involved at the same time. So you've got brokers carriers. What positions have the carriers taken on the claim? The very first mass tort case I did, I met with they booked me for 3.5 days, right? For and the half day I spent talking to the carriers. I spent talking to the separately to the insured, and separately to the plaintiff's counsel. And the reason I did it that way was the carriers in that case had not taken a position on whether they were going to be paying for the cost of defense, much less whether there was coverage. Yet they wanted to be included in everything. So we had to talk about that dynamic that was created by the carrier's expressed position on the claim. There was, because there was a tender of defense issue, that created some particular problems. It created a dynamic of who's authorizing the settlement. If the carrier hasn't taken a position on a claim, is the insured paying for the settlement? In that case, it was an international company, and yes, they were fronting the cost of the settlement. Also, is there coverage counsel involved? You need to know who the players are. You need to understand what those players' roles are. Okay. So then once you get past that and you have those preliminary discussions, we talk about scheduling mediation sessions. Well, how much time is going to be required? In the first one that I did, the first mass tort case that I did, I didn't know how much time was going to be required, but I was told that the carrier and the the parties had, or at least the counsel for the parties had discussed it and came up with this idea of 3.5 days for 68 plaintiffs. Well, I found out later that plaintiff's attorney thought it wasn't, none of them were going to get settled. So he was just going along with whatever the carriers thought. Well, actually, by the way, we did end up settling 68 in 3.5 days. Actually, to be quite honest, 2 of them I had to get additional offers in the following week. So not exactly true, but pretty much. So the parties will have discussed this before contacting the mediator. But look, talk to the mediator about, do you think we're going to be able to do this? And based on your conversations with separate counsel, are we going to be able to do this in 2.5 days? What's your vision for how this is going to be set up? Who's going to be, who are you going to need there? And so there's a lot of pre-planning that goes into this, and a lot of logistical obstacles to overcome, some of which, by the way, have become a lot easier because of Zoom. All right. Okay. Now, what I wanted to tell you, nobody in California really is used to joint sessions, right? There's a big it's almost like you've spoken blasphemy in California if you say, well, I'd like to have a joint session. What do you no, the parties hate each other. No, okay. Back east, they expect joint sessions. So, if you've got parties from across the country, you may have different expectations, but you need to get on the same page with the mediator. Most mediators, unless in a mass tort case, unless there is some wish to show a video or something about the scope of the construction project and things of that nature, or if there's a need for a site visit, narrated in effect by an expert, you're not generally going to have a joint session. But a mediator, as I've said, needs to, and this to continue on with the mediation, pre-mediation meeting situation. A mediator going into a mediation has to try to understand the parties' interests, their expectations of what they think the process is going to work. As I said earlier, the carrier wanting to be involved in a caucus with the insureds. That doesn't always work out. And you're going to want to impart, if you're the mediator, and you're going to want to hear, if you're the party, what's the mediator's approach to mediation. Some mediators are more evaluative, and some mediators are more facilitative. The usual successful mediator is a combination of those things. All right. But it's important to understand that. Look, if you're doing a construction defect case, you're not expecting a facilitative mediator. You're expecting a mediator who is bringing some expertise to the table and is going to be evaluative, at least in terms of how the mediator sees the evidence that has been presented to him. You're going to want to know going into that mediation, and your clients are going to want to know who's going to be in the room with us, who's going to be in the other room. Are there people there that have authority to settle this case? Are you going to want to put people such as subcontractors who are similarly situated? So one of the things that a mediator can do, and you might suggest this to a mediator if he hasn't done it or she hasn't done it, let's have a schedule. What are we going to do? one of one of the mass tort cases that I did had 900, well, in excess of 900 plaintiffs. So the idea was, okay, we'll do 50 a week for 15 weeks. I think the math works out on that, but that was the schedule. That was the suggested schedule. And this is something that you really need to talk to the mediator about, give the input. Say, if the mediator says, well, I think we should do it this way. Well, I don't think it's going to work because, all right, this may cause us a problem. We're not going to be able to do it that way. Know this going into as you're scheduling and before you're scheduling the sessions. Alert the mediator to anticipated problems. The carriers, and I mentioned earlier, when you have the case involving over 900 people with six-figure demands and 2- and 3-figure offers. What is the problem? Why are they in different universes? The effect of coverage issues. If there are some coverage problems, the mediator should know that, because the mediator has to be able to address those coverage issues. And there could be a disagreement between insurance carriers for different defendants, or even for the same defendant. I did a child molestation case where the issue was, when was the occurrence, all right? And there were multiple carriers involved and they were all carriers for the same defendant. There's issues that I don't want to get into now, but it's issues having to do with, did the event occur during our policy period? Okay, is there some sort of is there a need to deal with vertical or horizontal exhaustion of limits? Okay, if you're dealing with excess carriers, so the carriers, and again, the carriers desire to be in conversations with the insured. A lot of carriers are very, very strong about this, but the carriers who have not actually accepted tender of defense are in slightly weaker situation of insisting on being involved with in discussions where the insurers pick it up the tab, at least initially. Okay. So bottom line, mediator should make all parties aware of what he or she will be when he or she will be seeing you, and what the mediator is going to be doing. All right. You don't want people sitting around at a mediation and get to 5 o'clock and saying, I haven't seen the mediator yet. Okay. The idea of narrowing issues is very important. And I'll tell you, this can be done in meeting with those participants who might assist in determining what the issues are. For example, I've had construction defect cases where I'm looking at what the positions of the parties are, and I'm going, wait a minute. I'm not sure that they're really disagreeing to the extent they think they're disagreeing. So I will get the experts in a room, the experts on this particular issue, and I'll have the experts kick it around. And I'll say, okay, look, let's see. Do you disagree with what this guy just said? No, don't. Okay, well, then where is it that we do agree? And you can narrow issues in that way by talking to the right parties. if you know as a participant that there are things that may be able to be reconciled, let the mediator clue her in. Okay. You also should clue the mediator in on whether any particular issue needs to be addressed in order to move forward with other issues. I raised that issue having to do with the valuation on, where offers at the hundred thousands of dollars, and then I'm sorry, the demands in the hundreds of thousands of dollars, and then the offers are, paltry. What's the problem? Okay. Well, the problem of causation needs to be addressed. How are we going to best address that? In one of the cases I suggested that, I had a conversation with each side separately. How would you suggest addressing that particular issue? How are we going to get to this? Well, they have to provide us with more of this and that. Okay. Maybe that'll work. Maybe that won't work. By the time that particular case was, we had discussed that out, we had decided, I say we because everybody agreed, to a protocol of having a mock trial for some bellwether plaintiffs on the issue of causation. And in that particular case, we had actually 9 separate juries. This was not cheap. 9 separate juries. And at the end of the day, not one of the juries found causation. Now, that is a helpful, I thought, a very helpful thing. However, the plaintiff's attorney in that particular mediation took the attitude of, well, I knew I wasn't presenting enough on causation, but I'm going to have it. So her demands went up. Now, that did not help the case get resolved at all. In that case, I worked with her for about a year and a half after the mediation was ended by her walking out. All right. And she finally came up with causation, and I suggested sharing it, and they went back to mediation and they settled. Okay. So I've already given you a little bit about this, but if you need to settle, if settlements need to be negotiated for individuals one at a time, look for ways you can have it 2 at a time, or 3 at a time, or 4 at a time. And this example, which I've essentially laid out already, is you can essentially go on 2 tracks simultaneously. You can have, okay, on these 5 plaintiffs or these 10 plaintiffs, we're going to be negotiating for, and both sides recognize that their injuries are similar to each other, and we can therefore negotiate those claims all at one time. That's how we're able to get through 68 plaintiffs, by the way, in 3.5 days. Now, lump sum settlements are far different. One of the best examples that is just about wrapped up now is the gas leak in Porter Ranch. All right. If a lump sum settlement is going to be negotiated, however, as it was in the Porter Ranch situation, recognize that there has to be a way of structuring this so that the attorney is not the one making the determination as to which of the clients is going to get what dollars to the detriment of another client. You don't, if you're representing plaintiffs in those kinds of cases, you must figure out whether a conflict is going to exist. All right. So, because there's usually a finite amount of money and it has to be divided up. So, settlement structures like you use in a class action are sometimes very useful. And one of the things that you can do is you can have a point system set up where if your claim has this attribute, you get X number of points. In the gas leak case, it was okay if you're a mile or less from the gas leak, you get so many points. If you're 2 miles to 1 mile, you get another, you get lesser points. So that negotiating a point system would help. Also, having a third-party administrator can help, although, there are good and bad third-party administrators. But you do need a means of distributing the proceeds. You do need a means of determining how costs are going to be allocated. You're going to have to determine whether there are minors involved, and if there are, how those are going to be, how the consents are going to be obtained from the court. You have to deal with issues regarding liens. How do you clear out the Medi-Cal liens or things of that nature? All right. So other things that you need to consider also have to do with multi-party communication with multiple parties outside of the formal session. You also mentioned earlier using the results of a mock trial, for example. You need to consider something like that, or some other means of avoiding an impasse, which would have been very easy in the case involving the 900 plaintiffs, another hair product, by the way, case. The parties could have just said, something, we're just going to go off the litigation land, and that's how we're going to do it. How, excuse me, if you are a plaintiff's attorney, how do you try 900 cases? You can do bellwether cases, but that's going to require getting some sort of an agreement as to which cases are going to be tried first. You're going to also have to usually get court approval for which cases are going to be tried first. And other things that you absolutely need to keep in mind. And there are some people in the room who know this even better than I do. I will tell you, there are insurance issues relating to coverage. There are insurance issues relating to providing a defense. There are considerations of settlement based on cost of defense. There are considerations of settlement based on, let's call them intangibles, such as an adjuster has taken a position and doesn't want to come off that position. When I was representing sureties, I had a situation in which we had I thought, a very good chance of summary judgment. in a case involving a fidelity bond and $2.5 million with $2,500,000 in coverage, which the insured claimed was to be that there were separate incidents, and they wanted $25 million to settle the case. All right. One opposing counsel, after a deposition, admitted to me that a key piece of evidence did not exist. They were alleging that bribes had taken place. I said, and said, if you give me evidence of bribes, I'll be happy to make a recommendation. He says, there's nothing like that. Oh, really? Okay. So I recommended to the carrier that the case that we file a motion for summary judgment. We have a declaration from the people who supposedly gave the bribes, never gave a bribe. Declaration from the people who supposedly received the bribes, never received a bribe. Okay, your turn. And so we won on summary judgment. It was upheld on appeal. I never saw another case from the client. Why? Well, I found out later from somebody who had left the company that the adjuster had put in a memo that he had no faith in whatsoever, that he thought that the recommendation for summary judgment was just an effort to churn fees. He was not happy about, in effect, he would have been happier had the motion been denied. All right. There are things that you don't know. If an adjuster does not want to look bad, in a mediation, you never want the adjuster to look bad. When you're representing a defense counsel, you never want the adjuster to look bad. So what you want to do, however, is to the extent that you can be aware that the adjuster has to justify that settlement. You're negotiating not against the company, you're essentially negotiating with that adjuster. And whatever the adjuster has done and put in the file, he's having to or wanting to justify. Provide new information, and things may change. But in multi-party mediations, when you're dealing with millions and millions of dollars of claims under a general liability policy for a product, and an adjuster has taken a particular position and is trying to justify that position, you really, that is something that is absolutely something you need to be aware of. And if the plaintiff doesn't have the evidence, hasn't presented the evidence, hasn't presented the way by which the adjuster can justify recommending a settlement, there's going to be a problem, and the case very likely isn't going to resolve. One other thing, the need to have somebody there with authority is very, very important in a multi-party case. You have to have somebody with sufficient authority. Now that's always a tricky road to navigate. What's sufficient authority? Well, very often you will have a justification, an adjuster who will say, for example, I have sufficient authority because I don't think this case is worth more than $50,000. Well, there may be some new information that comes up. That case may be worth twice that. In a one-on-one case, it's easier than in a multi-party case where things have most certainly been roundtable. All right. The authority should be to have someone there who has the ability to say, you know something, we need to exceed, or we need to go to someone and have that someone available to which we might be able to make that plea. And it may not be today. It may not be today, but that person has to be clued in. One clue, by the way, someone who has not attended the mediation, it is more difficult to persuade than someone who has been there. They're seeing how the dynamics unfold is a great educational tool, right? So anyway, the mediating, just in conclusion here, mediating multi-party claims requires more planning than bilateral mediation, but is fundamentally the same. It's a facilitated negotiation. Number two, identifying potential obstacles really requires that mediators engage in planning and interacting with counsel to more fully understand the parties' interests, including insurers for the parties. And that requires more upfront work than in a bilateral mediation. And the third lesson, again, I go back to the first mediation I did in a mass tort case. The logistics may appear daunting, but if you have a fundamental understanding of mediation, of the mediation process, these are going to be overcome. And if you don't have a mediator that has the fundamental knowledge of the mediation process, that mediator has no business mediating a multi-party case. So that's pretty much all my prepared talks, my prepared talk on this subject. I'll be happy to answer any questions you'd like. Let me stop the share here. We'll give you.
I looked in the chat box, Lynn. I didn't see any answers. I mean, any questions, but the people that are on this call right now are all very experienced litigators.
Mm-hmm.
So probably all of us have done probably over 500 mediations.
I was right,
that's not
Lori.
even counting arbitrations. So I know I stopped my career at 125 jury trials. So,
right.
Mediation's probably, triple that.
Right.
Just a few things. I want to thank Lynn again. Wonderful presentation. Lynn has has podcasts on different subjects that are fascinating. So you may want to get the information about his podcast. You can listen to them at your leisure. Also, just a couple of announcements before we end tonight. We're going to next year have a in-person networking mixer, and I'm going to try to reschedule Erin Joyce because she's going to go through the new bar rules on client accounts, which are really important. And so I'm going to reschedule her. She was going to be for October. We're going to have our Christmas party December 1st at Walter's Restaurant in Claremont. That's where we'll do Judge of the Year, Attorney of the Year, Pro Bono Attorney of the Year, etc. The MCLE compliance period coming up, I believe, is from H to M. That includes me. San Bernardino County started e-filing. So hopefully all of you know that San Bernardino County is going to do e-filing now. They announced that at the May, East versus West, Rainbow Ranch, joint bar meetings. The presiding judge announced that. They've got it up and running now, apparently. So I think that's it. And I'll throw it over to you, Lynn, to say goodnight. If you want to tell a joke on the way out about, you got a
No,
mediation joke? Any
no, I don't.
mediation jokes?
I don't have a mediation joke, but I do want to add on to what one of the resources that you just said. In I believe in January, but you can check with anybody at ADR Services. Their ADR Services has like MCLE days. So if you're missing any of your
Oh,
if you're missing any of the specialty credits or you need more hours, whatever, ADR Services comes up with that every single year.
when do they do that?
I believe it's in January because I
Okay,
mean it's February 1st is the reporting period.
right.
But I believe it's in January.
Do you know what is it called? It's
I think it's called MCLE Day. They have
MCLE.
that.
Okay,
Okay.
so you just call them and they'll let you know about MCLE Day.
Yeah, and get on their mailing list if you're not already on, because if you're already on ADR Services mailing list, please, just you'll get an announcement of this. And by the way, if anybody does want to hear my podcast, I know Maria is a regular listener to it. It's one of the best way to do that is to get on either podclips.io or on your iPhone. If you have an iPhone, if you go on podcasts and if you Google my name, you'll get Masters of Dispute Resolution.
I put a link in the chat.
Okay.
Oh, okay.
Very good. Thank you.
All right, thanks, Jason.
That's exactly what I did. I just Googled your name and it did pop up.
Right.
Okay.
Right. Yeah. So it's we're into storytelling. This last one and this new season that's coming up, which is season 4. We're going to continue with storytelling, and you're going to hear some incredible stories about mediations that took place, how the parties had been affected by the conflict, how the mediation helped them, and takeaways, and the most important thing for attorneys and mediators alike, the takeaways from the events, including the mediation. What
Right.
there are tools that you're going to pick up, and I think you'll find it entertaining and useful. And I just want to thank Lori, and I really appreciate being invited to do this. I enjoy speaking on this subject, or any number of subjects. I think I've been here 3 times. So yeah. So
You're a fan favorite.
yeah, thank you. So and if you have any questions whatsoever, just email me, lslevy@lenlevymediate.com. It's on the PowerPoint that you're going to get, and or lslevy@adrservices.com. Either one.
All right. Thank
Night,
you,
everybody.
Lynn. I'm off
Thank
to
you.
Greece tomorrow.
All right. See, I hope they're playing the My Big Fat Greek Wedding 3, which
I saw it already.
Oh, you saw it already?
Yeah. I'm way ahead of you. All right. Good night,
Thanks,
you guys.
Good night, everyone.
All right.
Thank
Good night. Thanks, Jason.
Thank you.
Thanks,
Thank you,
Jason.
everyone. Good night.
Thanks,
Thank you
Lynn.
for your help, Jason. Bye-bye.
Good night.
Thank you, Lynn.